All right, good evening, everyone. I'd like to call the meeting of July 14th to order. Let's stand up, and invocation will be led by Member Keller and followed by the Pledge of Allegiance by me, I'm sorry.
Heavenly Father, we ask a blessing on our commission meeting tonight. Please give us the wisdom to make good decisions for our community. We ask a blessing on the Grogan family, the passing of our former mayor and commissioner, John Grogan. We ask a blessing for all our first responders, Lord, wherever they are. Keep them safe for us as they go about the job of protecting us. And finally, for our military, Lord, wherever they are in the world, keep them safe and bring them home to us. We ask all of this in your name. Amen.
Amen. Pledge of Allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, roll call, please.
Vice Chair Forges,
Here.
Member Keller,
Here.
Member Chacon,
Here.
Member Galvin,
Here.
Member Butler,
Here.
Member Fernandez.
Here.
You have a quorum.
All right, thank you. All right, next item on the agenda is the annual election. This is where we'll be electing our chair and vice chair.
Mr. Chair, I'd like to make a motion that we nominate Lou Forges as our chair going forward.
I'd like to second that.
All right, motion made by Mr. Keller and second by Mr. Galvin. All in favor, let's vote. Thank you for that. And can I make a motion? Sure. I'd like to make a motion to, and recommend Mr. Chacon as vice chair.
I second that.
Oh, I'm sorry, all in favor, let's vote. Motion carries, perfect, thank you for that. All right, next item on the agenda is, I'd like to get a motion for the meeting minutes for the last, for the June 9th.
I'll make a motion to approve.
Okay.
I second that motion.
All right, any discussion? All right, let's vote. Motion approved. Perfect, and, looks like we have no business, no new business, so miscellaneous item, we'll be discussing the impervious and open space workshop by developer, Mr. Lip.
Okay, good evening. So last meeting, what I brought to you, we had a workshop talking about impervious surface and open space. And this was kind of due to a situation that we're dealing with code enforcement. A lot of our established single-family subdivisions had an approved impervious surface of 50%. But a lot of the activity that's been going on over the past couple of years is after COVID and people spending more time outside, they've been wanting to improve their backyard areas, and it's actually come to exceeding that 50% and causing some code issues within not only our code, but code violations, where we wanted to look at it, what other people were doing in the area, and I brought it back to you all as a couple options to say, here's what we have. So I've gone back and done a little research, actually based on some recommendations that you made to me during that meeting. So I'm going to come to you tonight with kind of this draft policy that we're going to look to do as an interim as we're updating our land development code. So what is impervious surface and what is the coverage? So the impervious surface is actually the percentage of the lot area that's covered up by impervious materials. So concrete, pavement, the house actually is considered impervious surface. Solid decks, the swimming pool, patios or tents. So that's all that's considered as impervious, where water cannot percolate through to the ground. Lot coverage means the actual lot coverage of the overall square footage. So if you have a 10,000 square foot lot, a 50% lot coverage would mean you would be covering it with the house by 5,000 square feet. If you look at our minimum zoning descriptions and our permitted uses, a lot of our single-family residential impervious surface is around 50%, and a lot of our PUDs that were adopted or planned unit developments were adopted around 50%. Previously, kind of in the early 90s or even in the, late 2000s. But lately, we've been looking at impervious surface in recommendations around the 70%, up to 75%. And with the lot coverage of 40%, and you have an impervious surface of 50%, you only get 10% of that extra space of your yard to actually do something in. So we were finding that it was a little bit of a disconnect from not only what we're kind of encouraging people to be more outside and enjoy their yards, it just really didn't leave a lot of space. And in fact, even if you tried to put a pool in, a lot of times that exceeded the 50% of impervious surface with a swimming pool. So here's one of the examples within, I'm not telling you where it is within our community, but here's a house in our single-family subdivision that meets the 50% impervious surface. This one does not meet the 50% impervious surface. The funny part about it is they're neighbors. So as the neighbor that actually meets it right now comes in and says, well, I would like a swimming pool like my neighbor has, according to our code, we would have to deny that and say, no, you can't do it. Well, why did my neighbor get it? Well, now we have a code violation issue where they still have plenty of green space, especially in the front yard, and it's still kind of meeting the intent. So this was really an old policy that was kind of put forth that we're still trying to uphold, but it really doesn't make sense nowadays, especially where our other communities and our partners have an impervious surface of at 75%. And that's actually Orange County currently is at 75% for their single-family subdivisions. So in the June workshop, I asked a couple questions. If we wanted to increase it to maybe 70 or 75% to comply with kind of existing single-family developments that we have going on. Putting in here, 75% is kind of recommended to be consistent with a lot of the planned unit developments that we've approved in the past or recently. I was asked, what about 65%? What would that get us? Well, several of our single-family subdivisions would still not meet code, and we would have some difficulties with some existing violations that we're actually just kind of looking to clean up as these people have developed kind of a paved backyard or put in an extra pool and a little bit more pavers. To have them now come in and tear them all out because it's not meeting code doesn't really seem right as we're looking at what other people are doing and what could be allowed just by going off of an old code that we haven't updated in several years, and we're in the process of updating. It's something that we would like to kind of consider to relax as a policy right now as we explore in a little bit more detail and make it right-sized to what we're actually seeing in effect currently in the area. The third question was, do we remove impervious surface and just really talk about lot coverage and open space? I think we can explore this in more detail as we're looking in that new draft to the Land Development Code of how do we really want to categorize this. And then the last one, which I got a little bit of attention on, Winter Park actually only requires a front yard setback or policy to only have 50% impervious surface of the front yard, not really caring what goes on in the backyard, so 50% impervious maximum of their front yard. So looking at all these and then looking at kind of what we have going on in our development, kind of came up with a recommendation, and based on the conversations that we had last week, for an impervious surface policy recommendation as an interim while we're updating our land development code, for single-family planned unit development subdivisions that are already approved, we would look to have allow up to 75% impervious surface of total lot area with a maximum of 50% of impervious surface in the front yard, while still maintaining all land development code setbacks, utility, and drainage easements would be the policy that we're going to look to employ over this interim basis. So that's what I'm recommending to the Planning and Zoning Commission, and I would like to have a little bit more discussion and ask any questions before.
Yeah, I have a question. So by keeping the drainage easements, would that satisfy the original intent, I guess, with where water will be drained properly and all that, so?
Yes, a lot of these, when I was starting to look at the planned unit developments and some of these subdivisions, they do have that little bit of rise up in the house and a little bit of swale on each side for those drainage easements. We've always asked for anybody that's putting in a patio or anything to maintain those drainage easements, and it also helps keep that water from rushing out into your neighbor's yard. So within this policy, as we're looking at it, and as our planners are reviewing it and code enforcement and enforcing it, making sure that you maintain that 2 to 4 feet, depending on what that easement is for those drainage, making sure that that stays pervious and it can retain water. but still allowing you to fill up most of your backyard up to, up to 75% of your total lot area. And with the restriction on the front yard, we won't have to worry about a huge driveway in the front yard. You could almost really use most of your backyard up, except for these drainage easements and setbacks, because we still do require a 2-foot setback, so you're not going right up against your property line. And still meeting that 75% impervious surface while utilizing really a lot of the front for that grassed area or landscaping. We still do have a tree ordinance and tree requirements, so we're not gonna let you take down all your trees and completely pave over your backyard, but if you do have a sufficient amount of area to put in a pool or a paved backyard or even a pergola, we would like to allow that as a policy right now.
What would, if you don't mind, going back to the screens, what was the setback in the front of the property?
Oh,
25?
so maximum, so the front yard setback 25 feet.
Okay, so I was just kind of doing like some numbers, and just hear me out if you don't mind, so kind of justify the 50%.
Yeah.
Let's say that the lot is 50, because there's some lots now that are 50, and if the setback is 25, that's gonna put us at 1,250 square feet, right? 50% of that would
Yep.
be what, 675?
675.
So now if we have the driveway that goes from the road to the front of the house
Mm-hmm.
is gonna be 25 feet. If a double car garage, the width of that is 20 feet of the actual driveway, 20 by 25 is gonna put you at 500. And then we have those sidewalks to get to the house.
Yep.
They're gonna be cutting it really close. But some driveways have like the roundabouts.
Correct.
So those wouldn't meet the 50% in the front. So they might have to be either some variances. But when you put the 500 just on the driveway, not counting the sidewalks, to the 625, you're probably gonna be like in the 45-ish%. So it's gonna be a little bit tight. But I do get your point, and I like it and I agree, because I mean, the back is where you wanna enjoy it. But it might be cutting it close
Yeah.
at 50% in the front.
Yeah, because that's the minimum. So, I mean, hopefully they are a little bit farther back, depending on, how you positioned your house and where.
Yeah.
But you're correct. You're going to be very close to that you have your driveway and your walkway up at 25 feet. But that's still,
So it seems to be a nice middle ground.
Yeah,
So you
yeah.
have your backyard, you can develop further.
in your front
Enjoy.
yard, you're maintaining at
And your
only
front yard
50% of
maintain.
yeah.
Yes.
And the good
Trying
thing
not to have
is,
your driveway too wide, so you don't want to have, as a 2-car garage, you don't want to have 3 cars stacked up
yeah,
on the side.
and also the good
Yeah.
thing on that is that the front of the house is not always a straight line. It's always, it's 25 to the most, so some of it goes back. So you have the additional square footage that can count. Instead of the 1,250, I was just assuming if it was a straight line. But you'll probably get like the 1,350, 1,400 square feet, so
Yeah.
you'll go between 40 to 45%, which is still
And then you
doable.
gotta have the side yard, so we would not consider anything really on the side yard, so you have that existing kind of impervious on the side up until halfway back as you started reaching kind of that backyard. Yep.
I like it.
Okay. I think I have the same sentiment with the 50% front yard. I'm thinking forcing people to only have 2-car garages in most cases. You're trying to get cars off the street so that way public services can do their job, and basically, I think now we're forcing them to minimize.
But you will have an issue once you get the 3-car garage houses.
And at that point, you still have a lot bigger
Yeah.
lot size.
Okay.
So you are gonna be wider, so you probably still can meet that 50%.
Yeah.
What we're looking to not to do is have, most of these are
A whole
designed
front
for a
yard.
2-car household. You gotta be able to park those 2 cars, hopefully one in the garage, but not
Correct.
start having 4 cars in your front yard, or having the
Gotcha.
whole front space paved over. Because that's just gonna change kind of the aesthetic look of what this planned unit development and what the subdivision was really intended to be. And again, a lot of this is in our already approved planned unit developments where we're not getting a lot of the requests to expand their driveways. It's a lot to go in the backyard,
Yeah.
but it was
Correct,
something to really help preserve that, because we have seen a couple that we have had to go out and code that have decided that they wanted more driveway space, so they just put pavers up in the whole front yard, which a lot of the neighbors don't like. You don't have the curb cut there, it wasn't designed for that. So just to go out and put pavers, this would actually kind of make something where code would be able to look at it and say, well, that looks like more than 50%. Let's check that impervious surface.
Okay, I like the idea. Do
So,
everyone in the
Mr.
back.
Chair, I guess my question is, for our older subdivisions, is this going to cause any problems for the retention ponds? Because I'm looking at, we still have to have this drainage, and obviously as we make more of the area impervious, that water's got to go somewhere. And the older subdivisions were created with this rule in mind, that there wasn't going to be any more than 50%. And so when they did all their draining planning, and for their runoffs into the retention ponds and things like that, everything was considered on a 50% max. So now that we move it up, what does that do to the retention pond?
Yeah, so we started looking at our subdivisions and the planned unit developments. So a lot of them do have their master stormwater system that was planned for their 100-year events and more extreme events. So we're not anticipating anything on these kind of, daily rainstorms that we get here in Florida. Now, they were all planned on this 100-year storm event at 50%. Have to probably check a little bit more with engineering as we put this into the land development code as to, what should we do permanently with this? Is it something that we need to look at each one of these subdivisions? But what we're looking to do is just kind of relax, really the codes that have been violating already, and that's already out there, and we haven't seen any real drainage or, flooding problems to date. But it's something that we can look at as we make this more of a permanent solution.
Okay. All right. Any more comments on this? Cool. All right. This is not something this is just FYI, correct?
Yeah, so this is just a policy that we're looking to bring forward. Wanted to get your comments before we bring it up to the commission, and look to put it in place as a temporary policy.
Yeah, one more thing, and we also discussed about kinds of materials. Is that going to be considered now, or just trying to add too many things?
So we did just have a new policy that came out, an ordinance, because the Florida Department of Environmental Protection had a ruling on artificial turf and what's pervious and what's impervious. So as we're looking at this, we do have to consider there are now new brick pavers and other pavers type of materials that are considered pervious. So when we start looking at these permits and looking at when people come in to do their expansions, we have to consider what material it is and is it considered pervious or impervious. The more pervious really just helps out, and you still get your same outdoor look and outdoor feel. Just a lot of the old stuff that's in there right now is impervious, especially when you're talking about artificial turf and the pavers. But the more pervious you have, the better it actually is for your yard and overall. We're just trying to look to, like I said, right-size things to make it a little bit easier for a lot of our residents that have already utilized their backyards and put some pools in that don't meet that 50%. Even though the pool was approved and it's been there since the early 2000s, it's something that we're not looking to, go in and code violate and force somebody to remove.
Cool.
Also could be something where we look at, I know Orange County is considered that the pool itself, even though it is impervious, but as it collects water, it then just starts draining, so not calculating that under the impervious surface calculation. So again, this is a lot of stuff that we're still exploring in more detail as we do the land development code. We just didn't want to wait for months from now as we're starting to pull it all together when we're starting to notice that we're having some codes right now.
I think I like the way we're going with this. This is growth. Cool. All right. Okay, all right, let's move on to item 2 of the miscellaneous agenda. We will have a sunshine training by our attorney, Mr. Geller.
Now I see everyone. Most of you have seen a lot of these slides. I did add some new slides, so there'll be something new for everyone. But I think there are at least a couple of you who I haven't presented this to before. Correct me if I'm wrong. Have I presented to both of you?
Oh, yeah, I have.
Okay, you have, okay, all right. Then I think everyone else has probably seen some form of this presentation before, but it's really useful information to remind ourselves of. I'm going to cover the Sunshine Act, the Public Records Law. I'm going to also cover some provisions of Florida's Code of Ethics, especially conflicts of interest. I thought that would be of some interest to you all. The sources of this Florida Sunshine Law, it's the Florida Constitution, it's in the Florida statutes, and it means that everything that we do as a collegial body has to be out in the open. It must be open to the public. So it's all about doing everything with total transparency. This is the provision in the Florida Constitution, Article 1, Section 24. All meetings of any collegial body, that's you, the Planning and Zoning Board is a collegial body under the Florida statutes, at which official acts are to be taken. No official acts tonight, but I know you do on most other occasions, or which public business of such body is to be transacted or discussed, which you did tonight, shall be open and noticed to the public, which Miranda made sure that this was noticed to the public. The clerk's office takes care of that. This is the definition of a collegial body. It's a governmental entity marked with power or authority vested equally in each of a number of colleagues, and that is what we have here with the Planning and Zoning Board. So what is a public meeting under the Florida Sunshine Law? It's when two or more members discuss or take action regarding official business or policy. So if two of you, excuse me, if two of you were to get together outside of this meeting and talk about anything that conceivably, thank you, could come before this board, you would be in violation of the Sunshine Act unless that meeting was noticed and open to the public. There is an exception for committees whose sole function is fact-finding, and they have no decision-making authority whatsoever. That's not you. The public meeting requirements are found in Florida Statutes 286.011, and you can Google any of these Florida statutes. There's no mystery anymore to what's in our statutes. It says that our meetings must be open to the public. There must be reasonable notice to the public, and minutes must be taken, and Miranda is making sure that we're in compliance. So again, these are the three items that you must take care of to be in compliance. There is this has come up more than once, where you have two members of, say, a recommending body, such as this Planning and Zoning Board. You know, can you attend a city commission meeting to express your opinion on a matter coming before the city commission? Can you do that? And two of you are there. Two of you are there. The answer is yes, you can. You can. And we have an opinion by Bob Butterworth, former Attorney General of the state of Florida. He says that commissioners in attendance at such meetings may not engage in a discussion or debate about these issues among themselves. So long as you're not talking among yourselves, you can address the city commission about city business. All right. The Sunshine Law applies when you discuss with anyone else on this who's sitting up here with you, or when a matter may conceivably come before this board for vote or discussion. Consequences. They make it real easy. It could be a non-criminal infraction punishable by a fine not exceeding $500. And this is just a violation that's not even knowing. You didn't even know that you violated it. So, for example, let's say a new P&Z member is appointed to the board, and you talk to that new member. You have no idea that that person has been appointed to this board, and you violated the Sunshine Act. You could be found liable as having committed a non-criminal infraction, liable for $500. Now, that's Section 3A. Then you go down to Section 3B. Then you get to the knowing violation of the provisions, and then it becomes a misdemeanor of the second degree, and that's where the penalty goes up, 60 days imprisonment and or the $500 fine for each violation. So each time you get together and and talk about business when you're not supposed to, you can get found to have committed a misdemeanor. And I always tell people, please, 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 on my watch, just don't do this. Please don't do this. You don't want to end up as a face in one of my PowerPoint presentations. You just don't, like these two guys, and I'll tell you about these two Sumter County commissioners. They were removed from office for perjury, and I'll tell you about the underlying facts here. They were arrested, charged with perjury, then they were removed from office by the governor. All right, so here's the Tampa Bay Times. We're telling you what these guys did. So the Fifth Circuit State Attorney's Office, they received 3 complaints that Miller and Search, those were their names, Commissioners Miller, Commissioner Search, were communicating through Miller's wife. No one can be a conduit. Lou cannot say something to me, and I report to Joel, and then Joel reports back to me, and I go back to Lou. That would be a Sunshine Act violation. We're not going to do that. All right, but apparently Miller's wife was a conduit. So phone records show that Miller and Search contacted each other directly over 40 times between November 2020, when they were both elected, and July 2021, according to prosecutors. Miller told investigators the calls stopped in January or February after they realized the communication might be an issue, you think? And Search told investigators he had no contact with Miller outside of public meetings, according to court documents. The phone records show that nearly half of the calls between the men were made after January 2021. Arrest affidavits didn't say what they were discussing, but many of the calls were made just before or just after scheduled county commission meetings, according to prosecutors. So, very suspicious circumstances there. And then they lied about it, and then the governor said, enough, bye-bye. Public Records Act, let's talk about that. This, again, is a power that is given to the people of the state of Florida under the Florida Constitution, Article 1, Section 24A, and also it's codified, Chapter 119, Florida statutes. And it says every person, so it is literally every person, has the right to inspect or copy any public record made or received in connection with the official business of any public body, that's you, except records exempted. The section specifically includes municipalities and each board created pursuant to law, and this board was, in fact, created by an ordinance of the city of Ocoee. So you are under the public records law. And this is going to come into play when someone makes a request for your emails relating to whatever the issue is that came before this board. And we can get into that. But so this was, let's move on here. What's a public record? It doesn't matter if it's sitting in cyberspace on your iCloud. It doesn't matter if you've saved it to a thumb drive. It doesn't matter if it's a scrap of paper. The form does not matter for it to be a public record. So it means all material, regardless of physical form. I take that to mean it may mean that it doesn't have physical form, or means of transmission made or received pursuant to law in connection with the transaction of official business of any agency, and an agency is defined to be municipalities and its boards. All right. As I said, the form is irrelevant. It could be up in the cloud. I put a picture of clouds here to drive the point home. The Florida Supreme Court, in this case called Shevin v. Byron, defined what a public record is, gave a little more meat to the bones, so to speak. So it says that public records under Chapter 119 Florida statutes are any material prepared in connection with official agency business which is intended to perpetuate, communicate, or formalize knowledge. So those are the three criterion. Perpetuate, communicate, or formalize knowledge. We have an interesting case right now ongoing with the city of Ocoee where someone asked for metadata, all right, and we took the position in court that metadata is created automatically by the computer and not by a person. And so it's not prepared by a person, and it is not intended to communicate anything. It's just the computer talking to itself, saying, how it saves different files and that sort of thing. There's really no communication outside the computer itself. It's not formalizing any knowledge. It's not perpetuating anything that you need to have intent to do one of these three things. And there's no person with intent to do any of these things with respect to metadata. So that's something that may be a matter of law coming up. There may be some court cases coming down the pike on that. Notes for personal use are not a public record. I put that in a big headline for you all. So you all are free to take whatever notes you want at this meeting. I take notes on my pad here. They're mine. I'm not sharing this with anyone. Now, the second that I take my pad and I give it to Miranda, now it's a public record. Okay, but I'm not going to do that. I'm going to keep it to myself. So no one gets to see it, including if someone makes a public records request for those notes. I'm not giving them away. And this has been upheld by the courts. It's been upheld by the attorney general opinions. It's very clear. Notes to yourselves, designed for your own personal use and remembering certain things, are not a public record. All right. Notes relating to personal matters made by a public official. So this is this Butler case versus City of Hallandale. Said an email was sent by a mayor from her personal computer using her personal campaign account with blind copies to friends and campaign supporters, but not made in connection with official business of the city, was not a public record. So campaigns are completely different from the official business of the city. All right, transitory records. This is one of those things where it's a public record for some time, but then it's not. All right. So if someone, if the city invites you to attend a appreciation luncheon or some other event expressing their thanks to all of you for serving the city, and you get that email or you get it by text message, that's temporarily a public record. All right. Until the event's over, then it has no administrative value whatsoever, and then it's no longer a public record. So the rule is in the Florida Administrative Code, transitory records are public records and must be retained until obsolete, superseded, or the administrative value is lost. So if you get an invitation like that, just keep it. Don't delete it. Don't delete it. Just out of an abundance of caution, just don't delete anything. I mean, storage now is so cheap, on all of our phones, and there's all of it, the iClouds and the Google Clouds and everything else. Just keep stuff. So anyway, here's a 4 blurbs about what is included in the term transitory records, reminders about scheduled meetings, appointments, most telephone messages. If you get a voicemail, please call me back. Just save that until you actually, do the callback. Announcements, the holiday party, the group lunch, lectures, workshops, and this wouldn't necessarily apply to you, but just so you know, news releases received by the agency strictly for informational purposes and unrelated to agency programs or activities. Somehow that got thrown in with this transitory records definition. Okay, so as I said, normally this will affect you if someone makes a public records request asking for all your communications on a matter. So they want to know, Joe the developer wanted to discuss with you about the proposed new whatever development it would be. And I don't know what you all do. When I served on the Orange County Planning and Zoning Board many, many years ago, I would meet with developers because I wanted to know as much as I possibly could about whatever the item was before it would come before me. Now, when I would make a decision, I would never rely on anything outside of what came before me in the public meeting. But I would do those meetings, and there were occasionally public records, just setting up the meeting. Or the developer might send me an email trying to persuade me. And also, on the other foot, I would get tons of emails from the inhabitants of the such and such rural settlement, or whatever neighborhood is impacted by a development. My inbox would just blow up with all this stuff. All those, would be public records, and I would need to make them available on request, and I did on a number of occasions. So anyway, let's go to the duty of inspection and copying. Florida Statutes 11907(1)(a). Every person who has custody of a public record, that would be all of you on those types of items, shall permit the record to be inspected and copied by any person desiring to do so at any reasonable time, under reasonable conditions, under supervision by the custodian of public records. That would be Miranda and her office, all right, the clerk's office. They are the custodians of the public records. So typically when a record request comes in, it would be routed through the clerk's office. It's all set up on the computer system very nicely, and then her office would reach out to you. We've been asked for such and such records. Would you please provide us with these records? Or they can have the IT department assist you if need be. A custodian must respond to such requests in good faith. Okay, so the good faith is the standard by which a court would look at this. Are all public records open to the public? No. Some public records are confidential and exempt. There are confidential records. Say if the city is talking with somebody who wants to make a major economic investment into the city. There are provisions in the Florida statutes for keeping that confidential for at least temporarily. What's another example of an exempt public record? A public record prepared by an agency attorney. So that reflects a mental impression, conclusion, litigation strategy, or legal theory for civil or criminal litigation or for adversarial administrative proceedings, or prepared in anticipation of such proceedings. So that protects a lot of what I do when I'm representing the city in a lawsuit, at least while the lawsuit is pending. Once the lawsuit is no longer pending, then it loses that protection and it can be producible, discoverable. Same with an active criminal investigation. So until the investigation concludes, all that, any documents relating to that criminal investigation are not discoverable by anyone making the public records request. Once the investigation is over, then it's fair game. Right? Question, what about if only a small piece of a public record is exempt? You can redact the confidential information. So, this is medical information, so a lot of it gets redacted. All right, and also, we're not going to release Social Security numbers, bank account numbers, anything like that. Anything that has protection in Chapter 119, we're not going to let it go. All right, confidential records. I think I've covered some. Here's an example of a confidential record. EMS calls, any kind of medical related documents, whistleblowers. Some whistleblower, says, so and so here in my local government is doing something wrong, and then that prompts an investigation. So anything relating to the investigation has some temporary protection from disclosure, and the identity of the whistleblower also is protected for some time. Okay. The city cannot ask that anyone who asks for records identify themselves, so this can be done anonymously. May an agency refuse to allow records inspection because the request to the agency is overbroad or lacks specificity? Well, actually, there's a duty to go back to the requester and say, we need some clarification here. Now, what often happens is the request is incredibly overly broad, and we'll get pages and pages of requesting this document, that document, the other document, and then the city has the ability to give an estimate of how much time it will take to compile all these records and then an invoice is generated to the requester. Sometimes the invoices are for thousands of dollars. When they get the invoice, they will often either drop the request or they will narrow it down to something more reasonable. That's how that is often handled. But normally, when you all are asked for your emails, that's something you can search for pretty easily, on your phones or your computers. And so the overbroad issue, rarely would be something that you would be able to use as a defense. Okay. Can the records of a private person be deemed public records? Well, you all are private persons, although you're serving in an official capacity. Right now, you're wearing your official capacity hats, your invisible capacity hats on right now. An agency is defined as any person acting on behalf of any public agency. So I guess you all are now you all are agencies under the statute 119.0112. Whether a person is acting on behalf of a public agency depends on the facts. I think it would be very clear to most judges that a person who's serving on a planning and zoning board would be acting on behalf of the city. What are some examples of a violation of the Public Records Act? You don't want to destroy anything. Just don't destroy anything. My rule is just don't. I don't. Until established retention requirements has been met. I mean, 7 years. But just if the storage is so cheap now, why bother? I mean, you probably could after, I don't know, 8, 9, 10 years, or sometimes you get a new computer, and I mean, often these you could transfer data over pretty easily with clouds. But I would say be careful when you do get a new device. Make sure that everything you have gets uploaded to the cloud and then downloaded to your new device. That'd be something to be concerned about. The city, that's the city's duty to fail to acknowledge a request promptly. They're very good. They always acknowledge promptly. I think it's even done by computer. Is that right, Miranda? It does it. Okay. Failing to respond to a request in good faith. So you don't want to be in that boat. You always want to be cooperative with the clerk's office and giving whatever the records are. All right. Penalties. Yes, sir. Penalties here. Any officer who violates, again, as a non-criminal infraction, it's a fine not exceeding $500. Oh gosh, I didn't know that was a public record. Well, they can still get you for $500. Then you go to the knowing violation. It's subject to suspension, removal. From this office, it's a misdemeanor of the first degree. You'll recall, here we go, punishable by imprisonment up to a year. This is even worse than the Sunshine Act. Imprisonment up to a year or these fines. Any person who, then you go to the next step up, willfully and knowingly violates. So first it's you don't know, it's not willful. The next one is you know you're violating it. The next one, I know I'm doing it, I'm willfully doing it. I'm not sure if you know you're doing it, I'm not sure how you parse between the two, whether you're doing it willfully or not, but that's what the statute does. Any provisions of this chapter, or anyone who violates the provisions of this chapter commits a misdemeanor of the first degree, again, punishable by all these statutes. Okay, attorney's fees. A court shall assess and award the reasonable costs of enforcement, including reasonable attorney's fees against the responsible agency if the agency unlawfully refused to permit a public record to be inspected or copied, and the complainant provided written notice identifying the public record request to the agency's custodian of public records at least 5 business days before the filing of the civil action. So I guess my request to you is to, please cooperate with the clerk's office if a public records request comes in. We do not want to give someone making one of these requests grounds for seeking their attorney's fees. Okay, I'm gonna kind of shift gears to some other ethics issues that I thought would be of interest to you. Often things are right or wrong, it's very clear, and other times they're just shades of gray. All right, let's talk about voting and when you can abstain. Well, generally you should not abstain. No member of the board okay, may abstain from voting except when there is or appears to be a possible conflict of interest as prescribed in Chapter 112. All right, so let's talk about conflicts of interest. This is all defined by Chapter 112. So a conflict of interest is when you would vote on a matter which would inure to your special private gain or loss. So you could even come out worse for something, and it's still a conflict of interest. Okay, which is a little counterintuitive, but that's just what the law is. No member shall vote upon any matter. I can't read. Upon any matter which the member knows would inure to the special private gain or loss of any principal by whom you retain, or the parent organization or subsidiary of a corporate principal of which he or she is retained. Okay, or if you know that it would inure to the special private gain or loss of a relative or business associate. Okay, so if this is if you're part of you have shares in a company, that's something to be careful. Any kind of equity interest in a business that may come before this board, you want to steer clear of that. Okay, if any relative of yours comes before this board, you want to steer clear of voting on that. All right, and also business associates. Okay, so it could be a partner, it could be a joint venture, it could be any kind of business associate.
So I do have one question for you.
Yes, sir.
Rick, and I think I already know the answer, but I'm going to ask it anyway just to get it out there.
Please do.
You own shares of Lowe's. You own 10 shares of Lowe's. Lowe's comes before us and...
I wouldn't worry about that.
Yeah.
I wouldn't worry about that because especially when you're dealing with a publicly traded corporation, your ownership is minuscule. Like, I own shares of the total stock market fund of Fidelity, okay? So every single, not every single, but there's probably, certainly the whole Standard & Poor's 500 plus whatever represents all the mid-cap stocks, plus what represents all the small-cap stocks. I have some infinitesimal small interest in all these companies, but it's not going to affect what I do because it just doesn't really, it doesn't move the needle. Anything that I may do as city attorney or anything you all may do as a planning and zoning board member. So I think you're okay. All right. So if you do have a conflict, you must abstain, and then before the vote, publicly state the nature of your interest in the matter that you're abstaining from, and then within 15 days, and Miranda will help you with this, you'll get a Form 8B. It's also something you can just download. You have, she has her with her, a Form 8B, and you just fill it out, disclosing the conflict, you sign it, you give it to her, and she takes care of the rest. All right? Let's talk about special private gain or loss. So this is economic benefit or harm, and this goes to Joel's question. How do you measure whether you're part of this affected class? Well, you look at the size of the class, the nature of the interests involved, the degree to which all class members are affected, the benefit of the burden received by you as an official compared to others in the class, the degree of uncertainty as to economic benefit or harm, and if it's uncertain, the nature of the economic benefit or harm must also be considered. Think for a second that when Joel sat as a city commissioner, he would vote on the budget. He would vote to set the millage rate that he himself would pay, but that's not a conflict of interest. Okay, he's just one of however many thousands of residents were here in the city of Ocoee at the time. All right, but let's here's an example of a conflict of interest. And I thought you would find this of some interest. This is a voting on a septic to sewer conversion project. Coincidentally, we have one of these going on right now in downtown. Excuse me. So here, it was found that a voting conflict would exist, would be created if there's a vote on whether the city should proceed with a septic to sewer conversion project, that would involve her residents among 87 others, because the council member would receive guaranteed funds, parentheses, gains, of $24,000 from the city, and would have a mandatory outlay of funds she would personally incur if the project were underfunded, so there'd be a loss, thus incurring a special private gain or loss. So the decision here, this is the Commission on Ethics, they found that's a conflict of interest. Just, you got money coming your way due to a vote, just stay away from that, right? Let's talk about solicitation or acceptance of gifts. And, it could be something very subtle that you're not even thinking. You're invited to, I don't know, the Arnold Palmer golf tournament. So hey, I got an extra ticket to Arnold Palmer. Why don't you come with us? And then you come to learn that the person who invited you has some business that's going to be coming before this board. Just be very careful. I would not accept anything out of the ordinary. If it's a friend offering you the Arnold Palmer tickets, this is someone who you socialize with, you got the dinner with, then I wouldn't think anything of it. But if someone out of the blue who you're not expecting is making this offer to you, maybe that red light should go on, should start blinking. So this statute, 112.313, subparagraph 2, no public officer, and all of you are public officers, shall solicit or accept anything of value to the recipient, including a gift, loan, reward, promise, future employment, favor, service, based upon any understanding that the vote, official action, or judgment of you would be influenced thereby. All right. So I think that's pretty self-evident. You don't want to be accepting something in exchange for a vote. I mean, that is just clearly wrong. Okay, that would also be a misuse of public position, and this is found in section 112.312. Again, this is the agency. We talked about the y'all are agencies, so to speak. Y'all are public officers. You were appointed to serve on an advisory body, and then here it is, paragraph 6. No public officer shall corruptly use or attempt to use your official position to secure a special privilege, benefit, or exemption for yourself or others, okay? So for anyone else, you cannot corruptly do this. Now, but if it's not corrupt, if you're trying to do something good for the city, trying to get a special privilege for the city or benefit for the city, that's fine, so long as there's no element of corruption involved, all right? So what does corrupt mean? Okay, corruptly means done with a wrongful intent and for the purpose of obtaining or compensating or receiving compensation for any benefit resulting from some act or omission of a public servant which is inconsistent with the proper performance of his or her public duties. Corruptly, I mean, the picture, I try to find a picture of corruptly, giving them money under the table. That's just, quintessential corruptness right there. All right. This is the Commission on Ethics, one of their opinions. An element of misuse of public position is wrongful or corrupt intent. Intent generally is determined from an examination of all relevant circumstances. All decisions must be firmly rooted in a valid public purpose. I think if you just base your decisions on that, you're always going to firmly do everything you do for the public purpose, for the good of the public, and not for yourself in any way, or for any business colleague of yours, or for any relative of yours. You're always looking for the public first. You're going to be just fine, right? Here's Florida Constitution, Section 8H2. A public officer shall not abuse his or her public position to obtain a disproportionate benefit. So it's interesting that a lot of these statutes, find their root in the Florida Constitution. It's, these things are so important that they were placed in the highest governing body of the state of Florida. Florida Administrative Code, trying to figure out what's a disproportionate benefit. Well, it means a benefit, a privilege, exemption, or result arising from an act or omission by a public officer or public employee inconsistent with the proper performance of his or her duties. So there you have it. If it ever comes up, we can find it. Purchasing, doing business with a local government, just be very careful on this while acting in an official capacity. A public official may not purchase, rent, or lease any realty, goods, or services for the local government from a business entity in which the official owns a material interest more than 5%, or which you are an officer, director, or partner. So there's that 5% rule there. While acting in a private capacity, a public official of the local government may not sell, rent, or lease any realty, goods, or services to the local government. That's what it says. Okay? Unauthorized compensation. No public officer shall accept any compensation or payment, thing of value, that the person knows with the exercise of reasonable care, or should know that it was given to influence a vote or other actions. Again, this is just use your common sense, use your, go with your gut on this. If someone unexpectedly is offering you something, just red light, let it flash, and then you can reach out to the city manager to see about communicating with me to whatever the issue is. I want to try to get good information to you. If there may be, if something's unusual, we can search the decisions of the Commission on Ethics, because there could be something unusual that comes up that you just coming out of left field. Anyway, but the burden is placed on the public official to exercise reasonable care in determining whether you're receiving something of value to influence your official actions. So you all have the burden. So if there's some question about this, you have the burden. The larger the value, the more difficult it should be to justify being given for any reason except to influence. Don't accept the jet from Qatar or whatever it is. Okay, I use that just sort of justfully here. Just trying to make the point. The bigger the thing is, then you leave yourself more open to criticism. Okay.
So pay for lunch when they ask you to go to lunch to talk about something.
Okay. All right. Here's another Commission on Ethics opinion. Came out just a couple years ago. Acceptance and disclosure of accepting a preferential rate on a loan and donations from a GoFundMe platform. Okay. So Commission said you may accept loans from personal friends, regardless of the amount loaned or the interest rate. However, if the money is loaned to you at a preferential interest rate, then you must disclose on a Form 9 the monetary benefit derived from a preferential interest rate. So throwing that out there too, because who knows when we need a loan for to buy a house or a car or whatever it may be. If you're paying market rates, there's no, and especially if it's from a friend, you're really fine here. All right, penalties for this: impeachment, suspension, removal from office, civil penalty not to exceed $10,000. Now it's before it was $500, and then it just keeps getting higher and higher on these. All right. So who decides if there's a voting conflict or an ethics code violation? And the answer is the Florida Commission on Ethics, and they prosecute violations when a complaint is filed. You've heard all these opinions that they've been rendering, and here they are. Here's the Florida Commission on Ethics. No one sitting here should ever have to appear before these people. All right, but I'm going to tell you what the process is, just so you know, in the back of your head. It's just anyone can file a complaint, okay, against an elected or an appointed official. The complaint is confidential until the commission finds that there was probable cause or there's just a dismissal. Okay, so yeah, it gets filed, but no one can know about it, at least at first. Here's an example of a complaint. And at first, it's reviewed by staff, and they look to see whether if the allegations, assuming they're true, would they potentially violate any ethics laws. And if staff determines that it would not, that's That's one thing, but it is a low threshold, okay? So if it's legally sufficient, then the staff investigator begins a preliminary investigation, okay? And a report of the investigator's findings is sent to the accused and to the commission's advocate, who's usually an assistant attorney general. So you see the advocate, it's really almost like it's almost like a prosecutor. The accused gets to respond to the report. The advocate will review the complaint, the findings of the investigator, and then will draft a written recommendation on probable cause. So we're still at the beginning of the process. Is there a probable cause? And you've probably heard the term probable cause in the criminal context. You know, a police officer cannot effect an arrest without having probable cause that a crime has been committed. So it's the same standards, probable cause. Okay. And so then the commission hears the advocate's recommendations on probable cause, and then and it's a hearing. So it's a full-blown hearing that the accused can present argument in defense, and then at that point, whether or not probable cause is found, this whole complaint becomes public. And if there's no probable cause, complaint gets dismissed and bye-bye. If there is probable cause, then the commission may order further investigation or just go ahead and set a hearing. And it's an evidentiary hearing. It's the same as a little mini trial. If a violation is found to have occurred, the commission may impose one or more penalties against the public official, and the public official may appeal to the District Court of Appeal having jurisdiction. And then there's the power of the governor to suspend municipal officers, for malfeasance, misfeasance, or neglect of duty. Malfeasance is wrongful conduct. Misfeasance is performance that is improper or illegal. And then neglected duty, it can be the failure to perform your duty, either willful or accidental. So there is that power as well. And the governor has not been shy about exercising that power over time. It can also suspend for habitual drunkenness, incompetence, and permanent inability to perform official duties. So I wanted to throw that in there too. Not that it's going to apply to any of you, but just so you know, any violation of the statutory code of ethics constitutes malfeasance, misfeasance, or neglect of duty in office. Okay, so you violate any of these things, governor can kick you out of office. Governor has power to suspend a municipal officer, and you all are municipal officers. If you're arrested for a felony or for a misdemeanor related to the duties of office, I'm not sure what necessarily that could be, but just don't let it happen. If convicted of any of the charges, the governor must remove the official from office. If acquitted or found not guilty, the governor must restore the official to office. All right, so hope that gave you a lot of food for thought, or there's a lot of material there. Even if you've seen this before, that's a lot of material. And each time I look at that, I'm just reminded, oh yeah, that. So I hope you found that helpful. And again, do you have any questions pop into your mind off the bat?
I don't have any questions, but I've sat here for a while, and I do like it every time this presentation comes along, so.
All right,
It's
I'll
always-
see you next year.
There's
We'll do it
always
again.
there's always something new, something just a reminder, so.
Exactly.
We appreciate that.
Exactly.
Absolutely.
Appreciate you listening.
Yep.
Okay.
All right, so it looks like the next item here is project updates. Seeing a lot of stuff going on in Lakewood Ave.
We do. So up in Lakewood Ave, there is a sewer project going in that started right now. So there will be some traffic diversions. We're trying to do the project not during school hours, because understanding it's just two-lane road, so they'll be starting later when school is in, and then making sure it's all cleaned up at the end of the day, so when the students are walking home, it'll be safe. So it is something that we have kept our eye on, but it will be a 2-year project going all the way up to Worst Road. So quite a bit, but adding some capacity to that area, which we do have some projects. You did see a couple months ago, we had the townhome project going up there on Lakewood. There is still some other interest in some residential going up and down that area, but this does give us that opportunity to annex in those properties along Lakewood as we're going to be providing those services.
I'm sorry, so you're going all the way up to Clark Corner with the sewer?
Up to Worst Road currently.
Worst Road.
Yes, that's
Okay.
as far as the project is going for now. But eventually, yes, we are going to want to have our services going all the way up to Clark Corner, Ocoee, as you know, we keep expanding our urban services.
Cool.
Couple other projects. We do have an industrial office building going in off of Roper, 4,600 square feet, down off of, you can kind of see it off of the side of 429 as you're coming up. They support the Department of Transportation, but they're looking to put a new office in there on their property. We do have the Ocoee mixed-use project that's come in. That's off of McKee and Kissimmee. So they'll be looking at about 50 apartments and 10,000 square feet of retail. And then the Ocoee Commerce Park, which is a lot of activity that we have going on Ocoee Apopka on the west side. That's about 450,000 square feet of industrial, retail, mixed kind of workspace that's going to be coming in. That will also help support our Pine Street project as we start really looking at that business area of our overlay district as we start expanding. So those are a couple of projects that we had kind of recently looking at and coming in that you should start seeing coming across your desk pretty soon, hopefully, as we get this through the review process and looking for some of these approvals.
I see a metal building being constructed on Blueford, just south of Main Street. What, of the school? What is that?
So that's actually the floors direct off of their expanding their warehouse.
Okay.
But the O2B Kids, as you see the
Yeah.
daycare center there, there's a pad out front. We do have a proposal for some 1,000 square foot little retail office shops that would be going in there. We're still discussing that with them.
Cool.
Lots of activity going on in the city, so.
Amen to that.
I noticed there was a crew out doing some cleanup in front of the regional complex, so it seems like that's starting to move.
We do hear that starting to go. Yeah, they did start mowing that and fix the fence and fix their awnings. So we're hoping to see them come back in pretty soon.
Cool. Awesome.
Just out of curiosity, I don't know, what was going on White Road today? I know the state police were out there, where, at least where Clark Road was crossing White.
Clark and White?
There was a couple of state police cars out there. My wife came back to me and said, "Hey, what's going on?" And I said, "Nothing that I know of, but I just didn't know if we had something going on White Road that we had the police out there to
Nothing
oversee."
that crossed my desk in development services. That's usually maybe something up in the third floor that they would know, but
Okay.
no.
I'm just
I did
curious.
not hear about anything yet
All right.
today.
Cool. Any more questions for development services? Well, before we adjourn, I want to take as you guys know, I'm a man of a few words. I want to thank you all for nominating me for this position. I have served on many boards with the city, and I take nothing for granted. I hope that my time in this position would inspire those who want to be here, inspire those who are already here to eventually replace me and keep things going. Thank you for my son being here and witness his nomination. And I thank you all for that, and I will serve this position with integrity and respect. Thank you.
Congratulations. Look forward to working with you.
All right. Nothing else? Meeting adjourned.
Thank you.